So I get a lot of calls from people who've been hit in traffic, and I always try to tailor my advice to their particular situation, but there's some general overall advice that I almost always give. And it goes a little bit like this. I said, top level, the most important thing to remember is that you've had many different types of harm that were done to you in the crash, at least potentially. Injuries, medical expenses to treat them, pain, suffering, disability, loss of enjoyment of life, consequential damages. You have plane tickets to fly and go mountain climbing next week, and now you can't do that because you're hurt. Property damage, all kinds of different harm. And the law divides the harm up into primarily three separate categories for purposes of redressing the harm. And each of these three claims is a claim upon a different pot of insurance coverage that the driver, at least in New York State, would be required to carry against the harm that they might cause. Each of these three claims have different rules that apply to them. You don't have to pick and choose amongst them. You can do all three if you meet the requirements for all three. But it is very common for crash victims who I work with to confuse one claim with the other, and that, generally speaking, leads them to waste time and to forfeit valuable rights. So I go through the three claims when I speak with them, and basically they're the no-fault claim, which in New York State would be $50,000 worth of coverage for medical expenses, lost earnings, and certain incidental miscellaneous expenses paid out on a no-fault basis. I often tell people, just so that they understand the no-fault concept, you could jump off the roof of that building up there and land on the roof of this car, and that driver's insurer would have to pay up to $50,000 of your medical expenses, lost earnings, and miscellaneous expenses, because it doesn't matter whose fault it is. That's the rule in New York and in very, very few other US jurisdictions, because here in New York, we understand that drivers basically are the source of most of the harm on our roads. The second claim I tell people about is the property damage claim on $10,000 of coverage for property damage. For that claim, you need to demonstrate that there was fault on the part of the driver. Again, New York is a comparative fault jurisdiction. Most states are. And what that means simply is that it's not an all or nothing proposition with respect to fault. It could be a little bit your fault. It could be a lot your fault, and just a little bit the driver's fault. But in a comparative fault jurisdiction, as long as there is some percentage of fault, at least one thing that you can clearly identify that the other party did wrong, you do have the basis for a claim. And I do mention to people on property damage claims, it's important to think broadly about your property damage. It's not just your bike. It's bike accessories, clothing, jewelry, eyewear, personal electronics, your bags, your shoes, anything that might get damaged in a crash. And it's not just damage that affects function, because for drivers, the insurers are used to drivers coming and saying, oh, I came out of the supermarket in the parking lot, there was my brand new car with a scratch on the bumper. And the insurance company, if they bought that form of coverage, will just pay for a brand new bumper, like $1,500 on that car because it has a scratch on it. They're not worried about the function because they understand that the driver's upset. There's a scratch on their brand new bumper. Well, a cyclist often will forget about that, and we don't care about damage unless it actually affects function, but not so in the case of making the claim. You should make as broad a claim as possible for all types of damage that affect your property in any way. The third type of claim is a bodily injury claim that's based on injuries to your body. That is also a fault-based claim, so the same rules apply to it that I mentioned for a property damage claim, but in addition, there is a threshold that you must meet, a threshold level of severity of injury. You cannot bring a bodily injury claim if you have bumps and bruises that are going to clear up in a few days or weeks. The minimum coverage for bodily injury in New York State is $25,000. And the type of injury you need to have to pursue such a claim is going to be a fracture, a disfiguring scar or orthopedic injury. Obviously, things like death or loss of a digit or member or arm are going to qualify as a serious injury. Or do you have a significant functional limitation in the use of a limb or joint or other soft tissue that causes a loss of function of at least 20% compared to normal levels of function that the medical world has established as being a standard against which to measure people? It's that last category that gives rise to 9/10 of the litigation, that and the issue, of course, of fault. What is a significant functional limitation? How significantly does it have to affect you? Does it have to affect you in a certain core area of your life, or can it be with respect just to your hobby? And, does the limitation meet that 20% threshold that would enable you to get to a jury and ask them, how significant was the limitation? A lot of litigation over that, very confusing, but 3 separate claims. You can bring all 3 of them if you meet the requirements for all 3. You need a lawyer for that third one in most cases. You don't necessarily need and may not be able to get a lawyer for the no-fault claim or the property damage claim because the fees just aren't there to make it economically viable for attorneys to handle those types of cases. So as a general matter, it's only people who have bodily injury claims, which they can pursue and then share a third of that fee with their attorney from, which is the typical deal in a bodily injury representation. Only when you have an attorney representing you on bodily injury are you likely to be able to have that attorney help you with the no-fault claim and also with the property damage claim. And so for those people who aren't seriously injured, and you may be out of commission for weeks or even a few months and not have a serious injury, those people are underrepresented. Because of the way the system is set up, there is no way to pay a lawyer enough to make it worth their while to represent that person. And in those areas of no-fault claims and property damage claims, the insurers take tremendous advantage of crash victims because the insurers have their lawyers, they have their game plan, their adjusters, and they just sit there and, they'll make some offer, maybe, for your medical expenses, and what are you going to do if it's not enough? You're going to litigate the claim yourself as a layperson. So few people do it that it's an enormous area of savings for insurance companies to shaft crash victims who don't have bad enough injuries to enable them to retain a bodily injury lawyer who's going to help them with all 3 of these claims. And that's one of the biggest problems with the system that we have in New York, which by and large is much better than we have in many other states.